96. Chelsea, you want rebuttal in this case?
I'm thinking that I should reserve much of my time for rebuttal.
Well, that's fine.
If that's okay.
Well, what do you want to reserve?
Well, 10 minutes.
Okay, tell us quickly, how does this case differ from the other?
There are really only two factual distinctions in this case. The one that they rely on, and I think they don't even really seriously rely on it, is that this individual voluntarily went to an Article 9 facility for treatment at the end of his prison term. So he's not technically a Harkavy patient. But G5 is not limited by its terms to Harkavy patient. It expressly includes 402 commitments, and it wouldn't make sense to limit it in that manner. Someone who has voluntarily accepted commitment to Article 9 can still present as serious a danger. They recognize the need for treatment, but they may change their mind. The treatment may not be effective. And that issue, while it may reflect on the person's mental abnormality or their need for supervision as opposed to commitment, it wouldn't change their status as a detained sex offender. The only other factual difference in this case is that here the individual was still a Harkavy patient at OMH when Article 10 was enacted, and so OMH actually had begun its Article 10 review.
Not strictly speaking a Harkavy patient, but still a patient.
Yes. Yes. Yes, an Article 9 commitment, I should say. They had started that review. It wouldn't have made sense to take that any further because the question under Article 10 would be what the person's status was when we were looking at an Article 10 commitment. And this person now being returned to docs, that issue wouldn't come up for another year or so. So
if instead of being sent back to docs, he had been set free after you began the review, could you still proceed under Article 10?
I don't think so. The Article 10 has a provision where once a case is reviewed by a case review team, they make a determination to not refer the case to the Attorney General's office. This is 10.06F, I believe. And that would end it. There's not really a vehicle for starting the process anew. If they've made a substantive determination, we're asking for just that one look.
Once you start the review, he doesn't get released unless you decide
if there's a determination.
Sorry?
If there's a determination. I mean, if they start and don't finish, which is what happened, but if they decide not to review, the individual gets notice of that determination, and then there doesn't seem to be a procedural vehicle to start all over again.
So why was this individual sent to a DOCS facility instead of being returned to an OMH facility?
I'm sorry, I missed the beginning of your question.
Why was this individual sent to a DOCS facility as opposed to being sent to a more secure OMH facility?
Well, he broke a patient's jaw. And there were possible criminal charges that were brought, and he was temporarily in a county facility, and instead his PRS was revoked and he was returned to DOCS. But he was found to be quite dangerous. Does that answer the question? I'm not sure I
think so.
Yeah. Okay.
So even he was voluntarily with OMH.
That's correct.
If he'd never broken anybody's jaw, but you had begun a review under Article 10.
Yes.
And suppose he gets up one morning and says, I'm not so sure I want to be here after all. Can he leave?
There's a procedure where OMH can consider converting him to an involuntary status.
Under Article 9?
Under Article 9. Yeah.
Okay, counsel. Let's hear from your adversary.
Good afternoon. May it please the Court, my name is Rachel Sievers. I'm here from Mental Hygiene Legal Service on behalf of Respondent Humberto G.
Does the voluntary nature of this have any bearing?
Yes, Your Honor, I think it does.
How?
I think that if you look at this Court's discussion of 1003G5, which contains the provisions for Article 9 admissions, this Court was very clear in discussing G5 as being in reference specifically to those Harkavy patients who had been previously involuntarily transferred to OMH custody under prior state initiatives. And the state, in their brief and in their argument in the prior respondent, specifically noted that this was a provision that was included in Article 10 specifically to address a narrow category of people. And as they stated earlier, that this was a precise population of involuntarily transferred people who had been sent from DOCS to OMH. Now, the respondent here clearly is a voluntary patient. We have his voluntary papers. He checked himself into an OMH facility, and I would submit that in light of the state's concession, that is a narrow category of people that were intended to be captured under G5, and this Court's discussion of that provision and the legislature's intent in including that provision in Article 10, that there is a difference and that they should be treated differently. And I think
Are you saying that regardless of the post-release supervision, regardless of the jaw-breaking, the whole thing, they never could have started an Article 10 proceeding against him because he's a voluntary?
I think that G5 shouldn't be applied to him because he is a voluntary.
That's a yes.
Yes. And as for the reason that he was transferred from OMH custody to DOCS, this is a psychiatric facility. This was a patient-on-patient incident. It's something that OMH deals with on a daily basis. And OMH has incident reporting. They have many ways to deal with patient-on-patient violence. MHLS gets incident reports for these types of patient altercations on a routine basis. OMH could have treated this incident as simply what it was, an incident, and kept him in OMH custody. And it wasn't.
He also could have been charged with a crime, some form of assault, correct? And
He could have been.
sentenced on that.
And he wasn't.
Sentenced on that crime.
Yes, correct. And he wasn't charged with the new crime. And the fact is that OMH chose to report this as a violation of illegal post-release supervision, and I would submit surrendered their custody of him to DOCS. This wasn't something that respondent had control over. He couldn't control whether OMH would give up his custody. This is something that OMH shipped him back to DOCS as a matter of punishment for getting in an altercation. And I would submit that that is not the respondent removing himself from Article 10 jurisdiction. It's something that OMH did of their own volition. Now, I just want to point out to the Court there have been some questions about why this law is treating people who are out in the community differently than people who are in custody. And I think that part of that is related to the statutory interpretation that we discussed extensively in our briefs, that 1003G defines the people that are subject to Article 10 as detained sex offenders. It then lists the types of detention that are sufficient for Article 10 jurisdiction. And as the trial courts have noted, the legislature could have extended Article 10 to all sex offenders out in the community or otherwise. And they specifically didn't. And I would say that that's an effort to limit the reach of a statute that is a really important infringement on liberty.
Why were they doing that? Why were they limiting the reach in your view?
I think that this can be considered a retroactive statute and something that's being applied to people after they've served their criminal sentence and being added to, as a result of their sentencing, a potential treatment in a secure facility. And this is, as I said, a vast deprivation of liberty and something that
Isn't Harkavy 1 part of the answer to Judge Piggott's question? That is, wasn't Article 10 designed to reach the people that Harkavy 1 said that Article 9 couldn't reach?
I think that Article 10 was enacted in part because we've had this group of people who were transferred, and this Court said that that wasn't quite the appropriate mechanism to use for transferring.
Wasn't it also, wasn't there a debate at the time between how much resources are we going to apply to sex offenders? Because you being MHLS, I think know probably better than anyone. I mean, there's only a limited amount of money for mental health services in the state. If they applied it to every SORA candidate, for example, I mean, I don't know how many trials we'd be having a day. So they limited it to detained sex offenders, and now we're in this netherworld of, you know, whether you're legitimately contained or not. And aren't we focusing too much on that as opposed to the care and treatment we're trying to get to these people and save the public at the same time?
Well, I think that this is a treatment statute, but I think that it's a treatment statute that was aimed at a particular population, and that is detained sex offenders.
It struck me, you're right, but it struck me that the protections here there are so many. I mean, the only civil proceeding I know where we have a jury of 12 instead of 6, that you have a preliminary hearing instead of simply a proceeding, that you're entitled to counsel to be assigned to you. I mean, in no civil case that I know of do we do that. So they've done all of these protections for the person that they're bringing this action against. Whether or not they technically fit within, you know, I was legally detained or not, seems to me almost irrelevant to the purpose of the statute, which is to protect the public and to get these people treatment.
I think that the reason we're focusing on whether you were legally detained or not is because the prerequisite of an Article 10 petition, in our view, is that someone is in fact in custody. And if you don't have that custody, you don't have Article 10 jurisdiction.
I guess the question is, what is the purpose of that prerequisite? Is that why? What is it that distinguishes people in custody from people not in custody that caused the legislature to treat them differently?
I think that some states have allowed sexually violent predator laws to be applied to people in the community. I think that the state enacted Article 10 in light of these Harkavy respondents who were in a type of state custody. They were in OMH custody. And I think that if Article 10 was passed with the knowledge that there was this group of sex offenders who had previously been in DOCS and who were now in OMH and in need of treatment, the statute was enacted to allow the state to have a mechanism to treat those types of individuals who were in state custody.
To reach the
and in need of
Harkavy, to reach the Harkavy people.
I think that that's the backdrop that Article 10 was passed in, yes.
If Humberto had not engaged in this altercation, would he still be in OMH custody right now?
I don't think that's clear. I think that he was a voluntary patient.
Could they have started an Article 10 to have him remain in OMH custody?
They would have, if he was there as a voluntary patient, if they had converted him
Yes.
to an involuntary status, it's possible that they could have filed an Article 10 petition on G5 status if he were there.
I guess my main question is why, because of this behavior, does he end up better off than if he had not attacked a fellow patient?
I think
What's the justification to give him more preferable treatment than he would have had if he hadn't engaged in this behavior?
going back to my previous discussion, I think first, he had no control over whether he stayed in OMH custody or not. It was their decision to send him to DOCS. Secondly, his maximum release date was January 2007. He has been in Sing Sing Correctional Facility since he was sent back on his illegal post-release supervision. So this is an individual who reached his maximum release date, sought out treatment voluntarily, was placed in an OMH facility, alleged to have violated his illegal post-release supervision, sent back to illegal DOCS custody, and who now remains in DOCS custody pending this Article 10 appeal. So this is someone who's now 3 years past his maximum release date, who's now still being held in a DOCS facility. So I don't think I would consider that as being rewarded or unjustly treated.
Is he receiving any type of treatment in DOCS?
I know that DOCS offers sex offender treatment. I'm not sure if this respondent is engaging in that or not. I know that often when people are pending an Article 10 proceeding, they don't engage in treatment because they have a pending proceeding. But I don't know about this respondent particularly.
Ms. Sievers, under Article 9, how long can they be detained? I mean, aren't they subject to review every, year or 6 months? Or?
There's a variety of periods that they're subject to review. It's usually 6 months and then a year and every 2 years. And those are new reviews where counsel is assigned and the court takes a look at the entire case again. Article 10 has annual reviews for people who are in secure treatment facilities.
Okay, thanks,
Can you-
Ken. I'm sorry, Judge Smith?
Just to take you back to the point you were discussing previously, as I understand it, you argue that we don't reach this whole lawful, unlawful custody issue because he's not a G5 at all to begin with, because he was a voluntary admission. Have I stated your argument rightly?
I think that would be accurate.
An alternative argument, obviously.
I think that you could, there's also a reverse argument to that, which is if legal custody is required for a G5 admission, he wasn't in legal custody either, because he was in illegal DOCS custody, and therefore G5.
I understand, and that's the same argument we had in the other case.
Right.
But you have, I think, an additional argument that we don't have to worry about whether this custody is legal or illegal because he was never subject to G5.
Yes, that's correct.
And what is the language in G5 that you rely on for that argument?
It's that a person is transferred pursuant to Article 9, and our argument is that in light of what the state and this court has determined G5 and that transferred pursuant to Article 9 to have been intended for is involuntary transfers under 927.
You read the words pursuant to Article 9 not to include even though Article 9 does apply to voluntary admissions, you say in this context it doesn't.
Correct, in light of the statutory framework of this.
Okay, thank you, Ken. Rebuttal, counsel?
Just very quickly.
Sure, go ahead.
It's all the 10 minutes.
Okay.
In answer to your question, Judge Grappio, this individual could absolutely have been subject to an Article 10 if he hadn't engaged in this act of misconduct. He would have been a transfer directly to an OMH hospital pursuant to Article 9 under G5 of the statute, and the state could and actually did begin a substantive Article 10 review. So now the argument that his voluntary status somehow changes that, first of all, they didn't rely on this argument in the appellate division and therefore wasn't addressed. And isn't really properly before you now. But aside from that, there's nothing in the language of G5 that gives you this distinction. While it's true that the legislature certainly drafted the language specifically to meet the need of the Harkavy patients, on its face, the language is not limited to those patients. It includes 402 commitments, for example, which were not Harkavy patients. So it goes beyond the Harkavy class directly. And there's nothing in the language of pursuant to Article 9 that would give you a basis to exclude voluntary commitments. And finally, it seems to us that this Court has already answered the question of whether agency with jurisdiction necessarily requires legal jurisdiction at the time. In Harkavy 2, the Court ordered the State to go ahead with Article 10 hearings for the Harkavy patients, even though their custody at OMH was procedurally defective because they had been transferred pursuant to Article 9 when that process was improper. So we're not asking for a broad reading here. We're asking for a reasonable implementation of that ruling and the statute in order to avoid frustrating the legislative intent here.
Okay.
Thank you.
Thank you. Thank you both.